Thank you so much for your patience as we get started here. I want to wish everybody a happy LGBT Pride Month, and thank you for coming to the Failla Commission's program tonight. The big buzzword this year is the 50th anniversary of Stonewall and all the Pride events, but we wanted to highlight sort of a different anniversary tonight and shine a spotlight on a case that's gotten a little forgotten, I think because of developments that happened afterwards that maybe had a little bit broader impact. But it's a really amazing story. When I sort of discovered it and started to learn about it, it's really an amazing piece of legal history that I'm so thrilled we're going to be able to give you a little sense of tonight. In some sense, when I started talking to people about this case, everyone said, you have to invite this person, you have to invite that person. I think we're going to maybe scratch the surface really on everything that was going on sort of behind the scenes and around this case. It's really a story of a public health crisis, a housing crisis, a political crisis. There's a lot of moving parts here, but we're going to do our best job tonight to give you a sense of the Braschi case. First up, we've got some opening remarks from our Deputy Chief Administrative Judge for New York City, George Silver.
Thank you. I'm going to try to, my remarks will be very brief, and I'm going to try to keep on script because you know what happens when I go off script. The one thing I do want to say is I want to thank everyone for coming this evening, and especially my colleagues, the judges, for showing support for this really important event and this important month that we have Gay Pride. So good evening and welcome. I'm so proud to be celebrating the legacy of the Braschi decision here in my home, 60 Center Street. I am also proud, as a New Yorker, that the Court of Appeals decision was the first time in our nation's history that an appellate court concluded that same-sex relationships were entitled to legal protection and recognition. As an openly gay man, I am proud of all that has been accomplished in the wake of this decision. I will never forget the momentous day in 2011 when I had the opportunity for the first time to preside over same-sex marriages in New York. I also thought I might find someone at that event. I would figure there would be a lot of single people. But unfortunately, I came up short, although a woman did ask me out, and I did go. But I thought it would defeat the purpose of doing the same-sex marriages. But that was really, really a terrific day, and I remember how wonderful it was. And I'll tell you one brief story, is that I wanted to look nice because I thought I actually would meet someone. So I went to a fancy barber, and I had a facial, and I had to shave. And while I have the towel over on me, there was a filming crew filming two guys. And I said, and of course I'm telling my guy with the hot towel, I said, what are they here for? Turned out they were following them because they were going to be getting married. So I said, take off the towel. And turn out I said, I'll marry you. And it was wonderful. So the next day they came in and I married them. And they loved it because they got to go to the front of the line. But it was really a great experience. So following the case, LGBT individuals and same-sex couples were given the right to petition to adopt. The Hate Crimes Act of 2000 was passed, raising the penalties of crime committed on the basis of sexual orientation, and beginning in November of 2019 on the basis of gender identity and expression. Lesbian, gays, and bisexual individuals were granted the right to serve in the military, and conversion therapy on minors has been outlawed. And while there is still much to be accomplished, this case teaches us that the longest, most difficult journeys begin with a single step. Tonight, as we begin our celebration of Gay Pride Month and all that has been achieved by the LGBTQ community, it is only fitting that we acknowledge the importance of this decision and the path to equality that has set us on, all of us. Thank you.
Our next speaker to provide some opening remarks is our incoming co-chair of the Failla Commission, Justice Anthony Cannataro. He's also the administrative judge of New York City Civil Court.
And I will very briefly say that on behalf of the Failla LGBT Commission of the New York State Courts, I want to welcome everyone to Manhattan's 2019 Pride Month celebration. This is actually our official kickoff program for Pride Month. The Failla Commission will be sponsoring programs throughout the month of June, or Pride Month, as it is affectionately known, in courthouses all around the state, from Islip to Buffalo, and just about everywhere in between. And I have to tell you, those of you who are here, that might not seem like much of an achievement for us in New York City who have been attending events like this in this courthouse for so many years. But make no mistake, in just a few short years of its existence, the Failla Commission has helped to shine a light in the best possible way on LGBT judges, court employees, and court users in places where we had never really been noticed before. And that is a fantastic accomplishment. And for this progress, I want to thank all the commissioners of the Failla Commission, some of whom work in courts around the state, and others who are leaders of the New York legal community. I especially want to thank Executive Director Matt Skinner, who does so much of the heavy lifting when it comes to putting these events on. And Matt, seriously, thank you for the amazing job that you're doing. Very importantly, I also want to thank Chief Judge Janet Fiore for having the courage and the compassion to create the Failla Commission shortly after taking over as New York's Chief Judge. And on a more personal note, I want to thank Chief Judge Fiore for the vote of confidence in appointing me as the new co-chair of the commission to pick up the reins after our original founding co-chair, Justice Marcy Khan, steps down later this year. And continuing the great work that she has done, as well as that of former co-chairs Justice Elizabeth Gary and my new current co-chair and new partner in steering the commission, Justice Joanne Winslow, is going to be, I am sure, an awesome responsibility, one that I'm very much looking forward to taking on. We have an absolutely phenomenal program scheduled for you today, and all our speakers are now here. And we're going to be talking about a landmark case and a legendary judge that both mean a lot to me as someone whose career in the courts started with a clerkship for a judge of the New York Court of Appeals, a judge who happened to be a good friend of Judge Titone's, and a judge who is actually sitting here tonight next to Judge Titone's former law clerk, who got me my job at the Court of Appeals. So as you can see, we are all one big happy family. So I don't want to stand in the way of those proceedings. We have an incredibly impressive list of speakers. But before I sit down, I just want to thank our long list of co-sponsors, all of whom are listed in the program that you have for tonight's event. And finally, to all of you for coming out to support and learn about the history of the LGBTQ community and the contributions that we all make to the life of the courts and our state and our nation. Thank you again for your support, and I wish everyone a very happy Pride Month.
So it's appropriate that we gather here tonight in some sense because the case actually originated in New York County Supreme, and it fell in the lap of then Justice Harold Baird Jr., who later became a federal judge across the street at the SDNY. But Braschi actually won at the trial court level, and then unfortunately had there was a different approach taken by the appellate division. But we have tonight the individual who argued the case when it then went on appeal to the Court of Appeals. He was a young ACLU staff attorney at the time. Today, he's the Bruce Bromley Professor of Law at Harvard Law School. So I'm so delighted to introduce Bill Rubenstein.
Thank you all very much. I now feel like I'm the only gay in the room who didn't become a judge. I missed the boat. My colleague, Nan Hunter, who was the director of the ACLU's Lesbian and Gay Rights Project when we litigated the Braschi case, was to be here tonight and was going to open with some remarks to put the case in a more historical context. And unfortunately, Nan couldn't make it, so I'm tasked now with both doing what she was going to do and doing what I was going to do. But I'm going to try to do it all without taking too long. So I'm going to say a few things about the historic context in which Braschi arose, and then talk about the case specifically a little bit. The celebration of the 30th anniversary of the Braschi decision coincides, of course, with the celebration of the 50th anniversary of Stonewall, which prompts two initial observations. The Braschi decision was far closer in time to Stonewall than we are to the Braschi decision. It was a part of an earlier era. That said, it can feel like Stonewall started a march of continual progress from 1969 through 1989's Braschi decision to the present. Such a narrative misleadingly draws Braschi away from its historic setting, with hindsight bias making today's setting seem far more inevitable or predictable than it felt at the time. It is accurate to remember that the initial decade after Stonewall was one of enormous growth in the LGBT communities. Different identities took shape for the first time. Organizations formed, barriers were challenged. At the end of 1980, at the end of that decade, the New York Court of Appeals struck down the state sodomy statute on constitutional grounds. We didn't know it then, but the decision marked the end of the Stonewall era, the end of 1980, and as the new year, 1981, came in, the beginning of another era. In January of 1981, Ronald Reagan was inaugurated, ushering in 12 years of conservative Republican federal government and federal judges. By that summer, the Centers for Disease Control were reporting the first cases of immune deficiency among gay men, with a disease that was named by the end of the year, gay-related immune deficiency, or GRID. Mid-decade, the Supreme Court ruled in Bowers versus Hardwick that the Constitution did not bar states from criminalizing same-sex sexual activity, that LGBT people possess no constitutional right to privacy. Here's a story that I always come back to that captures the feeling of that moment for me. In the wake of the Hardwick decision, Skadden Arps and Wachtell Lipton, two of the major law firms in New York City, hosted a fundraising event for Lambda Legal Defense Fund. This was in 1987. It was the first time any major law firm agreed to place their imprimatur, however implicitly, on LGBT issues. The occasion was so momentous, this is unbelievable, the occasion was so momentous that the New York Times sent a reporter to cover it. And in the Times article, the Times reported that newspaper photographers were not permitted to take pictures freely at the party because, and I quote, some participants feared that if their presence became known, others would assume that they were homosexual. The ebullience of Stonewall was a distant memory from a different era, yet the resilience and the anger that stirred action then resurfaced across the community. The same month that Hardwick came down, my colleague Nan Hunter launched the LGBT project at the national office of the ACLU here in New York. I was in the midst of graduating from law school and starting a one-year clerkship. I immediately wrote to Nan, who I greatly admired for her prior work on reproductive freedom issues, and asked for a job that didn't exist. And I told her I wanted to work on AIDS issues because my friends were dying, and I assumed I would too. That next year, I joined Nan, we launched an AIDS project, and I was officially a public interest lawyer. Every public interest lawyer's dream is to have a mass of cases to choose among, as this helps ensure that you can frame the legal issue you're pursuing with its most sympathetic factual foundation. Miguel Braschi's case was one among a mass, but this particular mass was a nightmare, not a dream. Every Braschi-like case started with a death in the family, almost all by AIDS, and then proceeded, almost always with stunning speed, from death to eviction. In the days before text messages and emails that might have softened the blow by enabling you to take a breath before you were forced to respond, the phone would simply ring in our offices, and when you picked it up, someone would say, Bob died over the weekend, and when I got home from work on Monday, there was an eviction notice in the mail. And the next day the phone would ring, And when you picked it up, someone would say, John died last month, and I just got back from the memorial service to find an eviction notice tacked to the door. And the next week the phone would ring, and this one I remember in particular, and you picked it up and someone would say, I'm calling from a payphone at St. Vincent's, where I'm having a portal inserted in my chest for my ganciclovir, and I was just served with an eviction notice in the waiting room. And we weren't even on the front lines. Legal service lawyers, legal aid lawyers around New York were living in housing court, staving off evictions while gay men and so many others suffering from HIV disease were busy dying or tending to the dying. With that background, I hope you'll forgive me when I report that the facts of Miguel Braschi's case were perfect. First, he and Leslie Blanchard lived in a rent-controlled, not a rent-stabilized apartment. This was helpful because the rent control ordinance was open-ended, barring an eviction of any surviving spouse or other member of the deceased tenant's family without further enumeration. By contrast, the rent stabilization law, which applied to about 10 times as many apartments, came with an administrative regulation that had a long list, not including same-sex couples, of people who would be considered family members. With rent control, we were writing on a blank slate. Second, and better still, Miguel and Leslie had a good lawyer named Owen Winsig, who did a brilliant thing at the outset of the case. Rather than waiting for the landlord to commence eviction proceedings against Miguel in housing court, Owen filed a lawsuit seeking an injunction against the eviction here in the Supreme Court. As I remember it, and I'm sure many people can correct me if I'm wrong, this meant that Miguel's case could actually proceed through the appellate division into the Court of Appeals, while the housing court cases would proceed through the appellate term to the appellate division and were much harder to get to the Court of Appeals, if at all. Third, Miguel and Leslie not only had a long-term relationship marked by love and commitment, they also had objective indicia, proof, in the form of photographs and letters and family declarations and financial interdependence, all of which made it into the record of the case. Owen secured an injunction from Judge Baer. Nan and our colleague Judy Levitt and I wrote an amicus brief when the case was in the appellate division, and after the appellate division reversed, we took over the case in the Court of Appeals. Every public interest lawyer's dream is to have good legal precedent on which to rely. The Court of Appeals had, as I noted earlier, struck down the state sodomy law on constitutional grounds 9 years earlier, but it subsequently tossed out an effort by New York City's mayor to bar sexual orientation discrimination in government contracts on the grounds that the city lacked the authority, and it had never once recognized a gay same-sex couple in any way. Indeed, 5 years before the Braschi case, the court had rebuffed a gay couple that sought to use the adoption statute to create a legal form for their relationship. Against this rather bleak backdrop, we made 3 strategic decisions in arguing the case. First, we consciously chose not to argue that Miguel and Leslie were spouses of one another, and rather argued only that they were family members. The statute, of course, protected spouses from eviction, so we could have made this argument. But it seemed to give the court an easier path to frame the relationship as family, not spouse. And it simultaneously sidestepped a rather deep dispute within our community at the time about whether marriage was, in fact, our ultimate goal. Second, although the cause of Leslie Blanchard's death was not in the record of the case, we consciously chose to frame the case as an AIDS case. And a series of amicus briefs from the Gay Men's Health Crisis and Lambda Legal Defense Fund greatly assisted us in that effort. Third, although Miguel and Leslie were relatively well off, we consciously chose to emphasize the effect of eviction and the eviction ordinance on less well-off New Yorkers, particularly those in need of public assistance. And a series of amicus briefs from legal services and community groups greatly assisted us in that effort. Every public interest lawyer's dream is to win unanimously. Well, actually, every public interest lawyer's dream is to win. The decision itself was remarkably narrow. Judges Kaye and Alexander joined Judge Titone's opinion, and Judge Simons and Hancock dissented. That's 3-2 so far. That meant everything hinged on Judge Bellicosa, since a 3-3 tie would have affirmed the loss below. And Judge Bellicosa's decision concurring in Judge Titone's outcome barely eked across the finish line. But victory it was. The victory was surprising for several reasons. First, we had counted on securing Chief Judge Walkler's vote, but when I stood to argue the case, much to my surprise, he stood up too, turned around and recused himself, walked out of the courtroom without explanation. Second, I'll let Judge Titone's son illuminate his family's history, but at the time, we knew that both Judges Titone and Judge Bellicosa were Catholic graduates of a Catholic law school, and we were of course aware of the fact that the Catholic Church was adamantly opposed to same-sex relationships. I've written in my notes footnote, but I want to raise this into the text. It's also important to acknowledge that the Catholic Church was also the largest provider of social services to people with HIV disease in the city at the time. And that fact was not lost to us in arguing the case either. Nonetheless, we hadn't assumed we would get both Judge Titone and Judge Bellicosa's vote. We had been counting on the fact we only needed one of them if we had Judge Walkler's vote, so we were surprised to get both in the end. And third, and most surprisingly, most importantly, was the language of Judge Titone's decision itself. And I'm just going to take a minute to read from the opinion so you all can appreciate exactly what the Braschi case heard. In ruling that Miguel and Leslie were family members with one another, Judge Titone said the following for the court. The term family should not be rigidly restricted to those people who have formalized their relationships by obtaining, for instance, a marriage certificate or an adoption order. The intended protection against sudden eviction should not rest on fictitious legal distinctions or genetic history, but instead should find its foundation in the reality of family life. In the context of eviction, a far more realistic and certainly equally valid view of family includes two adult lifetime partners whose relationship is long-term and characterized by an emotional and financial commitment and interdependence. This view comports both with our society's traditional concept of family and with the expectations of individuals who live in such nuclear units. Hence, it's reasonable to conclude that using the term family, the legislature intended to extend protection to those who reside in households having all the normal familial characteristics. Marriage certificates are rarely called fictitious legal documents, and gay relationships are even more rarely labeled normal or traditional. As important as the outcome of the Braschi case was its legacy, first, the state of New York relatively quickly, within 4 months, though not without a fight, adopted regulations extending the decision to the rent stabilization side of the housing market, where it secured protection for the vast bulk of tenants in New York City. What that meant, as one of the legal aid lawyers who worked on the case, Paris Baldacci, wrote a few years later, was that over 1 million households in New York State are governed by a standard which has the potential of protecting lesbian and gay families from eviction from their homes. And this constituted a major advance in the ongoing struggle to push the law to encompass the reality of our families. Second, the potential proved potent as housing courts then effectively extended the decision beyond the well-documented, decade-long family situation to couples in shorter and less documentable situations. And third, of course, the opinion laid the groundwork and was later relied on by courts in same-sex marriage cases themselves. Every public interest lawyer dreams that any case she works on will be remembered 30 years later, so I'm thrilled and deeply honored to be a part of that memory. In preparing these remarks, I was forced to sit and think hard about 1989, and what came flooding back was a fleeting sense of victory in the midst of a tragic era of loss. The phones soon stopped ringing with eviction cases after the Braschi case came down, but it would be another 7 years, in addition to the 8 years before this, before protease inhibitors would be developed and the deaths would start to slow. The Braschi case came down smack in the middle of the height of the AIDS epidemic in the United States. Those blasted years when men would wake up in the morning and find a lesion on their leg or a thrush in their mouths. and be dead within months. Some years later, looking back on that era, the poet Mark Doty reported, quote, "I can hardly remember how it felt now, that relentless hopelessness." The Braschi decision was a glimmer of hope in that sea of despair called 1989. Thank you very much.
Thank you so much, Professor. The next speaker I'm going to have come up recently became the president of the State Bar Association on Saturday, so big congratulations to him for that. But he's a shareholder at Greenberg Traurig, he's a former counsel to the New York State Attorney General, former federal prosecutor. He's had an amazing career. But what we'd like him to talk about tonight was how he was a clerk to then Associate Judge Judith Kaye back in 1989. He's also the co-editor of a new book that I believe came out 2 days ago also, about Judge Kaye's life and with many of her opinions within it. So if you're a Judge Kaye fan, as I assume many people in this room are, please check out his new book as well. I remember the day she passed away, I remember Meredith and I were working on a tribute to her from an LGBT perspective, and the paragraph we did about Braschi said, you know, her name wasn't officially on the, as the author of the opinion, but it really gave you a preview of what was to come from Judge Kaye. If you put a word like, simple but profound word like family or parent in front of Judge Kaye, she could do amazing, groundbreaking things with that, especially for the LGBT community. So please welcome Hank Greenberg.
Thank you, Matthew, for the plug of the book and the introduction. You read it exactly as I wrote it for you. That was great. That was great. It is such a privilege to be here and join all of you and the distinguished speakers you've heard from, the professor and the others, for all of us to be here and celebrate the transformative power of law and how through brave and courageous lawyers like Professor Rubenstein and others, day in and day out in courts, we can affect social change. That from bleak and despairing times, we can live in a time, at least with respect to same-sex marriage, where it is long overdue, has become a constitutional right. And it is an honor to join this group and to talk about that. I'm here because I had the privilege and the incredible good fortune to clerk for Judith Kaye from 1988 to 1990, when the Braschi decision was decided. So I was present. It was my good fortune to be there when the foundation was laid for the recognition in law of same-sex couples. I was 28, and as you heard from the professor, the legal landscape could not have been bleaker. We were living at a time, I had just graduated from law school a few years ago, my third year in law school. Bowers versus Hardwick was decided. Unthinkably, the Supreme Court upheld a Georgia sodomy statute. One of the writings by a former Chief Justice of the U.S. Supreme Court invoked the Bible in defense of upholding that statute. We were living in a time, as you heard, where AIDS was ravishing the nation. By 1989, over 46,000 people lost their life to that disease. 3 out of 4 gay men of the 46,000. So when the Braschi case came to the court, we were also living in a time when all of a sudden the words like original intent came to the fore. Attorney General Ed Meese said that would be a thing. A recent Supreme Court justice said that's how we should construe statutes. So we were living in a time where it required prophetic powers, which I surely did not have, and I doubt that any of the judges at the time in 1989 could have had, of a time like we live today where sexual orientation is a legal irrelevance, where same-sex marriage is a constitutional right. One could not imagine those things in 1989. And that was the legal landscape, that was the tragic world landscape we were living in 1989 when Braschi comes to the greatest common law court of last resort in the nation, and I had the privilege to serve with one of the greatest judges that great court has ever seen. You know, it's the nature of the Court of Appeals that it decides questions of first impression. And the cases that come to the court oftentimes are ones where there are arguments on both sides that might seem very plausible, at least on its face. And in 1989, the Appellate Division First Department actually rejected the appeal that Professor Rubenstein had raised. It was a respected court. And the case comes to the court. And interestingly enough, as I recall the environment of the court, it was not only brilliantly litigated, but what I remember was that the beguilingly simple issue that was presented before the court, whether a surviving partner of a same-sex couple could be deemed to be part of a family, it wasn't a metaphysical question, but it didn't seem like an extraordinarily complex question. And there was that whole original intent view of the world that kind of argued, oh my goodness, the relevant statute, when it was enacted, whenever it was enacted, couldn't possibly imagine that that would be a family. But the skilled and brilliant litigators, what they did, as I recall, is I don't recall the case actually raising a profound legal issue. What they did so masterfully was rehearse a set of facts and told the story of Miguel Braschi and Leslie Blanchard that seemed, I think, in the minds overwhelmingly, at least to the clerks at the time, and thankfully for judges of the court, to present a factual plateau that made it unthinkable that the court would do anything else but accept the argument that was made on behalf of Blanchard. And so, as I recall the case being decided, two things stick in my mind. One is Judge Kaye came at a conference the day the case was argued, and she walked in and spoke to her law clerks, as was her wont, and she said the court was going to reverse the First Department's decision. And that was wonderful. And then she said, Vito Titone is going to write the opinion for the majority. I adore Judge Titone. He was an extraordinary man, a beautiful man, a lovable man. And in 1989, he had only been on the court for 3 or 4 years, and as an appellate division justice, I think I can say without fear of contradiction, had not sort of written a series of decisions that would have led one to believe that he was going to become the great civil libertarian that he did become, the champion of liberalism on the court, the conscience of the court. One wouldn't have seen that in his appellate division record. And in his first 3 or 4 years, there were some decisions that suggested a more liberal orientation or progressive orientation. But one of the things that sort of struck you about Judge Titone, well, I mean, he was, as we've heard, as a Catholic, graduated from Catholic law school. He was from Staten Island, I think I can say without fear of contradiction, the not most progressive borough in the city of New York in 1989. And his personality, if you sort of traditional, a Bullion person, he couldn't possibly be the one who would have struck the blow that led to the foundation of the recognition of same-sex couples in law. So when Judge Kaye came back and said it, I remember, oh wow. The other thing I have to confess, and again I'm showing you perhaps my own lack of vision, it dawned on me as an interesting case, an important case for the professor's client, a significant win. But at the time, I didn't recognize it. All 20 years of age, what little life experience I had, and as a straight male as well, I didn't see it as the landmark decision it became. And what I remember was the court session was completed in July, and I remember taking a trip to Seattle, Washington after a vacation where I was exhausted beyond belief and ready to collapse, and I was in an airport in Seattle. It was July 7, 1989. I saw a newsstand, and there above the fold in the New York Times, the highlighted headline was, and it read, New York court defines family to include homosexual couples. The New York Times got it. And indeed, fast forward 30 years, today we know this decision is a significant turning point in the law in New York State and ushered in an era, thank God, where at long last, yes, sexual orientation is a legal irrelevancy and same-sex marriage is a constitutional right. So let me leave you with these two thoughts. Braschi, among other things, stands not just for the transformative power of law, but what lawyers can accomplish in this society. Now, we know we live in challenging times. We know there's a lot going on in the world that concerns us, that discourages us. We know too many people in the public are losing confidence in the ability of institutions to solve problems. But Braschi tells us one important thing then that's still true now. When the cynics come up to you and they say government is failing, tell them, look at the American justice system. Day in and day out, courts and judges, upstate, downstate, throughout New York and this nation, are fighting for the rule of law every day. Remind you of one other thing. And Professor Rubenstein and others like him who have battled for social justice prove the point. We belong to the most influential, consequential, impactful profession in the history of the world. Lawyers right wrongs, we solve problems, we make society better. We are society's problem solvers. We are the foot soldiers of the Constitution. The rights the citizenry takes for granted amount to nothing without lawyers prepared to champion them. It was lawyers and judges, the bench and the bar, that gave us Braschi. It is lawyers and judges day in and day out today that protect our rights and the rule of law. Thank you very much.
So unfortunately, Judge Vito Titone, who Hank spoke about, can't be here tonight to talk about his opinion, but I'm delighted that we have another Judge Titone here tonight, his son, Surrogate Judge Matt Titone from Staten Island. I had the pleasure of attending Judge Titone's swearing-in ceremony in Staten Island in the winter. And I will tell you, I was joking to people that night that Pride started earlier this year because it was just such an amazing, it really was an amazing experience to be there that night. You had almost every important statewide elected official sitting in the front row on the stage, watching the first openly gay individual elected borough-wide in Staten Island get sworn into a very important position. So I'm so happy that Judge Titone is here tonight to talk about his father and provide some further remarks. Thank you.
Thank you, Matthew, and happy Pride, everyone. Happy Pride Month. So I don't have prepared notes, and I think that basically my job here is to give some insights as to some of the thinking behind Judge Vito Titone. Staten Island. We're going to get to that. Just want to point out that Staten Island gave you your first openly gay surrogate. Little insights. First of all, Dad very rarely talked about his job at home, and certainly the inside baseball was typically off limits. The only time that there was real debate, anger, frustration from one of Dad's opinions, and my mom expressed it very publicly, is when he gave the women the right to go topless in New York State. So that was a little bit harsh for Mom. But with respect to the Braschi decision, I have heard for nearly 30 years, and I want to point out that I was 3 years after the Braschi decision came out. I had graduated law school and myself was working pro bono for the Staten Island AIDS Task Force. I was out to my parents for quite some time at that point, to my family as well. So there was no secret that, yes, Judge Titone had an openly gay son. Did that factor into his decision-making process? I submit to you, absolutely not. It did not. And if I were to take any credit for it, first of all, I would not.
I would have to say it was really, truly, maybe friends of mine, if that was to be an impact, because, Dad grew up at a time when gay people were really just nothing more than a rumor. He fought in the Korean War, Italian-American Catholic. He didn't know gay people growing up. In fact, the closest that he ever came to gay people was Mom's hairdresser back in the 70s, Mr. James, who really influenced their lives, and he introduced them to some really exotic things like, clogs and fondue. But when friends started coming around, and they were police officers, detectives, firefighters, chief of the battalion chief, carpenters, bricklayers, one of whom I married. His perception of what gay people were challenged. They were not the stereotype that he grew up thinking that they were. I'm not going to make many jokes about my stereotypes growing up. But suffice to say, I don't think that him having a gay son influenced his decision. In fact, if you read the decision, he doesn't really speak to gay people having the rights of a family. His vision was very broad as to what a family constituted. And the problem that the Braschi decision had, and I have some inside baseball coming from Judge Bellicosa, by the way, who I actually wrote to me and spoke with this afternoon. Judge Wackler had to recuse himself. I know the reason why. I'm not going to tell you why, but it is a standard reason. So the fear was that there would be a split court 3-3. And the fear would be that because the case came from downstate, that an upstate appellate division judge would have the final say as to what the court's legacy would be. And that was a big fear for members of the court, as it still is today. They don't want an outsider, so to speak, writing their legacy, writing their history. Judge Bellicosa struggled with the issue. He knew that he was getting hammered by Judge Simon to go Judge Simon's way. And so it was really over a long, extended period of time that Judge Bellicosa came up with the idea of truly limiting what the decision should be, how he could get to yes. And that would be to limit the Braschi decision exclusively to rent-controlled apartments, and there you have it. Dad was very disappointed with that. To give you an idea, Dad started out when he started in the Supreme Court, he was the hanging judge. His arc went all the way to becoming the conscience of the court. He firmly believed that there was an inherent equality of all people, not just for gay people, but for all people. The reality of a family, Dad had seen firsthand from his family, so he knew that there are, different strokes for different folks. He might have said many, many times to me, but the reality of family life to him was really more not Catholic, Roman Catholic, but I want to say Italian. What binds you? What binds us? What binds this group of people? What binds these two groups of people together? And that was love. And he understood that two people, whether they were same-sex or not, can be bound by love. So I would never, ever want to take credit for my dad's intellect and for his ability to see a much bigger picture, because that bigger picture that he saw has always been much bigger than me and who I love. And Dad was more interested in how we love as a family. So there's some inside baseball for you. I'd like to show you this picture of when Judge Bellicosa announced his decision to go with Dad. And as you can see, it's one of the gayest pictures I have of my dad. And I think Judge Saparik is in the background there. So that's the inside baseball of who Dad was and how he came to be. Dad was a firm champion of LGBT people's rights. Certainly when I started pro bono work, Dad stood by me. And, you know, I don't think I could be more proud to have a man that I call Dad. So thank you all, and once again, happy Pride.
Thank you so much, Judge. Our next speaker, when I ran into him a few weeks ago, I was sort of shocked when he said to me, despite all the profound, amazing things he's been a part of, his work sort of around and involved with the issues in this case are the things that he's most proud of. So I'd like to call to the lectern former City Council member and State Senator Tom Duane.
That is true of everything that I've done, particularly LGBTQIA+, which I might now just say queer, so we're clear, it's just easier and faster. Braschi is the thing of which I am most proud that I was a part in making a part of the law of New York State. It was before I was in public office. It was really as an activist that I worked on that. And there's some, well, and I would even say that like there are some other things that are queer that I worked on besides marriage. Braschi doesn't just impact queer people, but in fact many other groups of people, as does hate crimes legislation and as does dignity for all students. Includes all students, including, and I'm a little bit proud of this, protections based on et cetera, gender identity expression, and weight, which I felt very strongly about, because there's nothing worse than being a queer, fat kid, let me tell you. It's a tough life. Dick Failla was the first openly gay judge of the Supreme Court. And to give you an idea of how that came about, in New York County we have a screening panel, and I got elected Democratic District Leader in 1982. I came in with Cuomo, the homo came in with Cuomo in 1982, and I asked to serve on the Judiciary Committee of the New York's County Democratic Committee, and I wanted to make sure that there was an openly queer person, but I also really wanted to make sure that there were two. Because one means that they have to say it over and over, they have to decide all the time, is this the time I should say it, should I come out now? If there's another one, and they can bounce off each other, then other people start incorporating it. So that really is very important. It's never enough to have one, like I had in the City Council, like in the Senate, because then the caucus is also meeting in my head, and it disagrees, and it's very problematic. So it's nice to have another one. But I think that made a big difference in terms of who it was that would come out of the panel and then become eligible by the county rules to be considered to be on the ballot to run for Supreme Court. I think Marcy Khan was the next person. But I did think it was very important that there be queer people around how it is that people either run for or are chosen to serve in the judiciary. I think it's incredibly important. And sometimes I feel like because it doesn't seem like such a big deal and everything's fun, never give up the franchise. Never, ever, ever. Like in New York State, we don't really have a political action committee for the queer community. They disbanded after marriage, and gender hadn't even gotten done. So don't give up the franchise, no matter what, because times are really rough. You see what's happening to our transgender sisters and brothers with the military, and Health and Human Secretary Severino under Trump is now forcing people to live in binary categories, which is a disgrace. So it can happen any place. Okay. So a man named Russell Pierce, who is a professor at Fordham, was an attorney at Chelsea Legal Aid, and he called me up and he said that he needed some activism on a case he had, which was Michael Brown versus two associates, because Michael Brown was in a rent-stabilized apartment. He was being evicted. His life partner had passed away from AIDS. It was a time when the family member of the person whose name was on the lease could come in and take everything as the landlord was nailing the eviction notice to the door. So it was losing homes, but it was losing not just the bricks and mortar of the home, it was losing everything. It was a terrible, terrible time. And I did help I created a group called the Chelsea AIDS Committee, all 6 of us. We had a demonstration. I told the cops, oh, just a little neighborhood thing on a Saturday. Okay, a sound permit, but not much more. Well, we closed down the street. It was front page of Newsday, and it was the lead story on all the local TV stations. I think that made a difference. Because soon thereafter, even though Michael Brown's case unfortunately was not successful, it really educated and provided a lot of legal fodder. But I do think that public opinion can make a difference, even though I know that all the judges here are completely immune from everything in the outside world. I think it does make a little bit of a difference, because how else are you going to see the world change if you don't see what's happening in the world? I'm terrified to not give people credit who deserve credit for making this happen in and out of the legal community. And I want to make just a couple other points. Braschi also was the decision that Eve Preminger used when she legalized or formalized the first non-biological parent of a same-sex couple, of the parent who was not the biological mother. And so the Surrogates Court in that case referenced Braschi. And Braschi's been referenced in a lot of other things. I have a friend, John Heilman, who's, among other things, has been mayor of the West Hollywood city, the city of West Hollywood, teaches a course in California on Braschi. And because, you know, your family, if you say your family, that's really what Braschi's about. If you say your family, you know what, if the Golden Girls had lived in a rent-protected or, I mean, you're gonna throw out Blanche? I don't think so. I'm just saying. All right. I also, you know, I have all, I want to say that Russell Pierce is also really good at, he got a lot of help from a lot of legal aid attorneys, and also Fried Frank was very involved in helping us. You know, that was the days, you still copy things in law firms, right? Mimeograph things. No, you actually copy things. I mean, it was very expensive. These cases were very expensive. And most judges held back after these cases started to come. They were sort of afraid to make a decision. And a lot of them didn't make a decision until after the Court of Appeals ruled in 1989. So a lot of people were in limbo. And there's a couple of attorneys, one in particular, Jim West, who I want to say it's almost a cottage industry that he led, of attorneys who were willing to take on cases of those who were not eligible for legal aid or legal services. So between him and a couple of other attorneys whose names I forget, unfortunately, you know, they were the ones who really fought so hard to keep people in their homes. And I am, honestly, I would have, I'm donating all of my archives to LaGuardia College, and I have all of the amicus briefs from various legal organizations, etc., but I also have all of the sign-on-tos, which was part of my job as this case went forward, from tenants organizations and unions and religious groups. So there was a really excellent list of people who had signed on to these amicus briefs as the case moved forward. Paula Edelbrook was not so much for marriage. She was more for Braschi and domestic partnership. Evan Wilson was more for the marriage thing. And Tom Stoddard, who sadly is no longer with us, had to sort of navigate that. He was the executive director of Lambda Legal Defense and Education during that period of time. But I had a very difficult conversation with Tom Stoddard, who I love. And he didn't really want to do these cases because he said, it's going to make bad precedent. We're never going to win these cases. And I was like, but everyone's getting thrown out anyway. What do we have to lose? And of course, Landon got on board. And many years later, he said, and I'm only saying this just because, like, to hear from him, because he's like a god, like, he said, you were right about that. Because the other thing that was happening was people were dying and their partners had nowhere to go. They'd go to GMHC, and fortunately, they were very high-powered and medium-powered and low-powered attorneys not with legal aid and legal services who were volunteering their times, and they were allowing tenants to sign stipulations saying that they would leave their apartments. And it was really important that they stopped doing that because we did have a chance. So that was also going on. I always say no one should ever be allowed to be a judge unless they hang out in the hallways, because that's where you really see what's happening. It was better when we all smoked, but it's still a good place to hang out to find out what's really happening with people. You could be like Paris Baldacci, write an article about it, then become a famous TV producer. I'm just saying, if anyone hears, I'm available. I need a job. All right, I think that is enough, although I'm sure I forgot to mention people who were really instrumental in it, and if I did, I'm incredibly sorry. There were judges that these cases would come before, from whom, I don't know, and because sometimes I would accompany Jim, or sometimes I was bringing people because they were calling me, and I would, bring them to meet Jim in court, or say, you're entitled to, services, your income dictates that. And it was wonderful. There were so many queer clerks to judges, and I strongly believe that they made a huge difference also. So it doesn't matter at what level and what role you are in the judicial system, we need to have representation, we need to have more diversity. And of course, not just queer, of course, many other people, even in Manhattan, which is probably one of the better places, we don't have that much diversity, as we don't have as much as we should have. And you know what? Maybe, did you say you were out to your father, or you weren't out to your father?
Oh, I was, completely.
Well, good. And even if he didn't tell you, good, because I was thrown off a case one time that had a gay theme to it because I was gay. I was thrown off a jury, so that's ridiculous. So fair is fair. A gay kid, that should be entitled, I'm just saying.
Dad never recused himself from it.
I don't know. I wonder where Saul Lockwood accused himself. I really do, but he's going to tell me. Maybe they will. Anyway, there is no substitute for sitting at the dinner table, or sitting at the legislative table, or sitting in courtrooms, no matter what your role is there. It changes everything. And that's what happened with Braschi. And it was tough to get, so don't let you people lose it. It was very tough to get. Hang in. Even if they claw on that wall, do not give up Braschi, because even if our marriage rights are taken away in New York State, we'll still have Braschi. Thank you.
Thank you so much. Our final speaker, I apologize, is not listed in the program, and that's because I actually found her 3 hours ago. But I'm so delighted that she agreed to come tonight and say a few words. Giannina Braschi is Miguel Braschi's sister, and she's much more than a sister. She's also an acclaimed writer, and she just got off a flight back from a trip to Europe, and I know she's tired, and I'm sure this is not the easiest thing to talk about, because sadly her brother passed away only a year after he won this case. But I'm so glad we've talked about the legal and the political implications. There was like a real human being behind this case, and I'm so glad we have a member of, literally a member of his family here tonight to tell us some more about Miguel.
You were great, all of you. I have nothing more to say but that dignity is the measurement of liberty, and that my brother found out one day that he had AIDS, and that his lover, his friend, his family had died of AIDS before, and he had a time bomb in his body. His body was a time bomb, and all of a sudden the rock was taken under his feet, and he was a very sheltered guy, and all of a sudden he finds himself in the world without nothing, naked, with not knowing what to do, but his dignity was the measurement of his liberty. So he found out the best lawyer in New York, and he contacted him, and he fought with all his mighty heart for what he thought was right. Thank you.
So thank you everyone for sticking with us tonight.